All right. Happy Friday. It is July 17th, I think.
Yes.
Yeah, July 17th. It's a little after 9 p.m. So that means it's time for the Casewalker Chronicles, the particulars. Same reminder as always, everything you hear from us is our opinion, our analysis based on public record. It is not legal advice. Tonight, especially, since we're doing something a little different, putting a brand new documentary up against the actual court file, this episode's going to be a little bit different. So I'm excited. We're going to try this out. We're going to see how it's going. In the chat,
I lost the sticker.
who watched, and technically, because it was, I think it's a two-part series. Don't quote me, but I'm 99% positive. Two-part series on A&E. I think the second one dropped at 8 tonight. So I don't know how long it was. But in theory, you may be able to come in tonight having watched both.
Yes.
But in the chat, let me know if you've seen the first episode. Anybody? Anybody? No one watched it? Oh, all right. Well, good. That's good for me then, because then that kind of means that I can say whatever I think, right?
Yep.
Okay. You haven't seen any of it? Have you ever seen any of the documentaries? Because there's a bunch.
Oh, yeah.
I mean, I guess you have a general knowledge of the case, though, so. So we do want to, we're going to do a couple quick updates from the week because it is Friday. And this will be 2 full weeks that we've done the particulars. So we do every Monday, Wednesday, Friday at 9. So this is episode 6. So for those of you that are joining us again, welcome back. For those that are new, welcome. We're going to spend the bulk of tonight on Scott Peterson. And we're going to close with some developments that we haven't talked about since episode 1. So let's go ahead and get into it. And we're going to talk about some updates that have taken place since Wednesday. Zaire Wade was arraigned Thursday in Pasadena. We checked the actual court docket directly rather than relying on press coverage. So, one count. Penal Code Section 273.5A, a felony injuring a spouse, cohabitant, fiance, boyfriend, girlfriend, or a child's parent. He pleaded not guilty that same day. The judge ordered him to stay at least 100 yards from the alleged victim and to confirm in writing that he doesn't own any additional firearms. After prosecutors said an unregistered gun was recovered from his home following the arrest. The docket also confirms a $50,000 surety bond standing as of the arraignment. The next scheduled proceeding is a preliminary hearing setting on September 24th. So we said that, like, my page has been covered in these cases, and that's why I really wanted to continue to push some of these updates because there's a lot of misinformation that's going around. Yeah. I don't want to say misinformation. I like to say that it's exaggerated information.
Yeah.
I think that's the better statement. So with that.
Following up from previous episodes, Nolan Wells, cause and manner of death are still pending. Toxicology results haven't come back. Here's what's actually confirmed this week. Named source by named source. Governor Tate Reeves, on the record to WLOX, confirmed a grand jury referral is standard procedure for unnatural or suspicious deaths in Jackson County. He said he's not personally seen any evidence suggesting foul play, but stressed he doesn't know all the details. Sheriff John Ledbetter told WLOX his office has interviewed more than 60 witnesses, including all 3 friends who were on the boat with Wells, and that the FBI is assisting with digital evidence, which he said isn't unusual since Horn Island sits on federal land. In a statement given directly to WLBT and Gray News, the FBI's Jackson office said, quote, "The JCSO Jackson County Sheriff's Office is leading and will continue to lead the investigation, and that federally they've been working to address interstate threats that were received by individual related to this matter.
End quote.
End quote. Sorry, I'm trying to make sure we don't miss anything in the chat. Okay. Dispatch audio released by WLOX from the Friends boat that evening records someone reporting that they were taking on water. Everyone aboard was confirmed safe. And GPS data obtained by CBS News from the Mississippi Department of Marine Resources tracks the boat's timeline that day, leaving the dock at 9:56 that morning, arriving at Horn Island at 11:14, and leaving the island without Wells at 4:31 that afternoon. Separately, per WLBT and Gray News, the family and attorney Ben Crump met with Jackson County DA Angel Myers McElrath on Wednesday. Crump says the family and law enforcement have agreed to a joint inspection of Wells' phone, following the family's earlier claim that some messages appeared to be missing when they got it back.
So a few things worth correcting. Since this case is moving through social media faster than it's moving through actual reporting. So the viral video where attorney Ben Crump says you can hear Wells arguing about his phone, a named friend, I'm probably going to say this wrong, Trayston Shepard, told both Rolling Stone and ABC News on the record that it's his own voice, not Wells's, and the argument was unrelated. 3 other named or identified witnesses back up his account. Separately, a photo Crump's own office shared claiming to show Wells at a pool party close to his disappearance was actually from a month earlier. Mississippi Today confirmed that directly with Crump's office, and to be direct about something else circulating, any claim that the independent autopsy results have already been released and prove foul play is false as of tonight. Every legitimate outlet we checked confirms results are still pending. If you see that claim, it isn't true. And I would really strongly urge people to take some of the stuff that is floating around at just face value, because there is a lot of things, and that's why I said I continued, and I did when I do my fact checking, I say a fact checking, I actually try to go to the court record first. And in some of the cases that we've covered since we started the particulars, they're not, like if we talk about Nancy Guthrie, there's no person specifically charged with that yet, so there's not necessarily,
we're going to get into that later.
The court. I'm just saying how if there isn't a charge, there's not really a court record,
right?
So you can't go to the court record. So then, like, there are some legitimate, I think, are more legitimate sources when it comes to
press
news.
Conferences,
right? So you think about law enforcement, things like that. Some of those press releases that they push out, those are what I try to look at next. And then if I am going to look at media, I'm going to look at what the media is, like who they are quoting. Yeah. So if it's a media report and it says it quotes FBI or the specific law enforcement, those and their direct quotes, I take that with a little bit more certainty than just like, sorry, TMZ pushing something out. I mean, I'm just going to say it. They can come at me. I just think that they're really quick to turn around stuff without necessarily verifying it.
Yeah.
That's all I'm going to say. So I try when I put, and does this mean that all of this is necessarily verified? No, it just means that I've already tried to check it against as many things as I can before I put it out there. Yeah. So that's what I'm comfortable stating at this time. And as it is Friday, the majority of your court stuff is kind of paused until Monday. So keep that, take that as you will. And again, I did check these several times today. And I do want to say, before we go into the next segment, we are talking about
Vinton County.
Yeah. I don't know if you want to talk about it or if I want to talk about it.
Well, so it was confirmed that a gag order was granted on July 14th for Gary Siders Jr. We confirmed the signed order ourselves, not just as news coverage of it.
Yeah, I actually downloaded that.
Yeah.
I'm out of space on my computer. I am in the process of looking for a new computer because that is how much work I do on my computer. Anyway, so yeah. Christina Sider's attorney filed a similar motion on July 16th. That one hasn't been ruled on yet. Elizabeth Sider still has a pending bond modification motion with no order yet either.
And Gary Sider Sr.'s competency evaluation is underway. That was ordered on July 9th. Nothing resolved enough for a full segment yet. So it's worth knowing where it stands.
That's where that stands. We are really trying to keep up with all the cases and bring you the most verifiable, so to speak, updates. So you got a notification on there.
From?
On the very top.
It's fine.
I can't read.
No.
So I guess I was kind of hoping we had a few more people on here before we started this segment. Because
all right.
this is the meat and potatoes.
It's Friday. Some people are busy. It's
I know. But what else would you rather do than spend your Friday with the particulars?
Yeah, I know.
I digress.
Scott Peterson.
This one. All right, here we go. Hold on to your hats. We're going to try to get through this. And we're going to see where this goes. Okay. So bear with us because considering we pulled a heavy amount of court record for this.
Thank you, Jess.
This is a lot. So here we go. Tag, you're it. You're going to lead us off.
Oh, gosh. Am I starting here?
Yeah, you can start there. That's fine.
All right. So, disclaimer, this involves the murder of a pregnant woman and her unborn son. Keep focus on the legal mechanics and the undocumented record, okay? Peterson is convicted. Presumption of innocence framing does not apply here in the same way. The legal question tonight is about the post-conviction process, not guilt or innocence itself.
So Scott Peterson was convicted in November of 2004 of murdering his wife Lacey and their unborn son Connor in Modesto, California. He was originally sentenced to death. That sentence was overturned in 2020 over jury selection issues, and he was resentenced to life without parole. He has fought the conviction through multiple rounds of appeals and habeas petitions ever since. So we are also going to give you a quick definition, okay? So since we'll use this term all night, and this show is built so you don't need to have caught a previous episode to follow along, a writ of habeas corpus is a formal request asking a court to review whether someone is being held legally. So basically with this, it's exactly the kind of filing I would review and I would flag in my investigating reports. So has it been like a case that's being actively fought, or is there something that the court is trying to weigh out, if that makes any sense? That was clear as mud, but that was the definition, so to speak. So this week, A&E aired a 2-part documentary called Scott Peterson, The New Evidence, built on the Los Angeles Innocence Project's petition. Tonight, we're working from the actual court documents, not summaries. We obtained and read the judge's order denying that petition and the prosecution's 903-page written response and the Innocence Project's own public statement of their claims. We are not reviewing the documentary, so to speak. Okay, we're telling you what these documents actually say. And I say that to say, I did watch 3/4 of episode 1. And I say that I only got through 3/4 of it because when they presented a claim, I would pause and I would go back through the documents to try to verify. And I'm like, wait, was that said this way? Or wait. And so I did that it took me a long time to watch 3/4 of that documentary. Yeah. So I will say I am not all the way through episode 1. And I am not at all through part 2.
Yeah.
But I will this weekend, and I will actually probably start episode 1 over again and watch it from beginning to end, and then I will do the same thing. So I usually watch it twice. before. But I will say that we're going to try to be as more focused on the documentation and what everybody's seen the trailers. Hopefully, they've seen the news. I've read a ton of articles about what they're claiming. So we're going to try to just base it around the documents and like the case and where the case stands today kind of situation.
Yeah, Matt is right. Is a lot of homework, and a huge shout out to Matt and Jess for planning their evening around this. This is great. This is fantastic. We enjoy doing this. This is why we do it. This is the reason we left our day jobs, because we wanted to do something that we actually enjoy and get fulfillment out of.
Yeah, I spend a lot of time doing records research because I like to do that. I don't know why.
She's crazy.
I really do. I like reading through it. I like cross verifying. So, okay, yes, this is what this says, but can I verify that like 4 other ways? Mm-hmm. And, you know, if there's something in there that I don't understand, or if there's, you know, like there's case law in there that I don't understand, I will go and pull that and read that so that I understand what they're trying to compare and contrast to.
Matt, so, you are 100%
correct.
It's the TISM.
Yes, it is. It's one of my...
Continuing on with Scott Peterson, here's the headline fact, straight from the order itself. This is Peterson's 3rd habeas petition filed August 4th, 2025, containing 14 claims. On April 27th, 2026, Judge Elizabeth Hill of San Mateo County Superior Court denied it in full. Her own words from the order: much of what petitioner pleads now is neither new, admissible, nor material. The court remains unpersuaded that petitioner has stated a prima facie case for relief on the basis of actual innocence. So essentially, it was full of a bunch of fluff.
We're going to get there.
I know.
Keep scrolling on down. All right, another definition. We'll see. I've put a lot of these definitions and talk points in here because I feel like it's very...
The law uses a lot of Latin terminology that is just the way it is because that's where our laws originated from.
Yes, and it's, I think, as for the common person, and I say common because I don't like to say like normal or regular. I prefer common.
Yeah.
But most people don't use those terms often. And
voir dire.
So it can be a little confusing. So that's why we try to break some of it down. Yeah. And throughout each episode, you will see this more and more as we build, because they're kind of all standalone episodes.
Oh, Star, thank you.
So we will, thank you, Star. So quick definition, the docket. You will hear us refer to the docket a lot. It's also... So the docket is the court's official running log of every filing, motion, and ruling in a case. So it's sometimes also called the Register of Actions, or if you've heard us sometimes say CCS.
Hang on, I gotta correct myself. I'm sorry. I'm so sorry.
Aunt Star.
Aunt Star.
I knew Aunt Missy was gonna say something.
Yep, she did. I'm so sorry. Aunt Missy, Aunt Star, we love you.
Gotta love it. So I lost my place. So CCS on other nights covering Indiana cases. That's the chronological case summary. The same idea. Different states label it for different. So the prima facie, a term straight from the order itself, means on its face at first look. It's the minimum showing needed just to get a court to seriously consider a claim at all. I was going to say something. Judge Hill found Peterson didn't even clear that first lower bar.
Mm-hmm. Yeah.
Do you know where we are?
Oh, yeah.
Okay. So you can go into the next one.
Oh, you want me to talk about that?
I'm already starting to sweat.
Okay. Procedurally barred, another definition, means the court is saying even if this claim might have merit, legal rules stop from considering it, essentially. Usually because it shouldn't have been raised earlier, or it should have been raised earlier and wasn't. Actual innocence.
So you were the undercut the verdict, right? Yeah. That's where you left off. Okay. So, sorry, we've got our ducks in a row, don't we?
No, we had a demi dog come in.
She's our guest star. All right. So where these 14 claims actually came from, straight from the informal response, which lays out the full procedural history. This was on April 18th of 2025. The Innocence Project filed an amended second petition, adding claims of new evidence and actual innocence. On May 29th of 2025, the Court of Appeal summarily denied those claims without prejudice and instructed Peterson to file a new petition in Superior Court. Then on August 1st of 2025, the Court of Appeal separately denied the one claim it had kept for itself, the juror misconduct claim. Those redirected claims became the 14 claims in what's being marketed right now as a brand new petition. The prosecution's own filing claims it his sixth bite of the apple.
Which is funny because the bite of the apple terminology in law, we just had that with one of our own cases that we are involved in.
Yeah, that was stated in there.
Through a defense attorney's objection to a motion that we had
And that's
filed.
all we're going to say about that.
I know.
But it is a common reoccurring
Yes.
thing you see within court filings.
Yes.
So,
Quick structural note here. The Superior Court is the trial level court. The Court of Appeals sits above it and reviews whether the trial got it right. It doesn't usually bear brand new claims first. Without prejudice, because we're talking about some of these terms here, means Peterson wasn't blocked from refiling. He just had to start in the right court. That's exactly why these claims get sent back down.
correct. So here's the part that's genuinely new to our reporting. Not from a press release, but from reading the informal response itself. And it's the strongest single fact in either document. And I will say also that I usually always have a notebook, okay, that I carry around.
You're fine.
What was
A
so
sticker.
I always have a notebook and I like to write down lots of things. So you will notice that as I was, like I said, I was trying to watch the documentary, and like I get to a point where I write down, episode 1, I list who says it, and then I go and replay and I get the actual timestamp and I quote what this individual has said in the documentary. So then I can go back and verify it. And I will say that I'm still trying to find this because I want to verify this fact before I say it to you. But I can tell you that it caught my attention what one of the individuals stated
In the investigation.
in the documentary. I was
the
like,
documentary.
I don't think that's correct, sir. So I am going to verify that, and I
Okay.
will talk about that on Monday once I verify that, because I think that was not true.
Well, one of the documentary's central claims traces back to a man the court records only as DM.
Uh-huh.
Multiple secondhand sources over 2 decades, 20 years, friends, and now deceased fellow inmate, an ex-girlfriend, have claimed DM said he was present for or knew about Lacey's abduction. Here's what the informal response documents happened. Here's what the informal response documents happened when someone actually asks him directly. In September of 2023, a defense investigator interviewed DM in person. And that's all we know him by is DM. According to that investigator's own account, DM denied ever telling anyone that he was involved in Lacey's abduction or murder, and said he didn't believe the actual convicted burglar would have been involved in taking her. 8 months later, Peterson's defense went back to DM with a statement they had drafted for him to sign. That signed declaration, the one attached to the position as evidence.
Petition.
I said petition.
I thought you said position.
No, petition as evidence leaves out his denial. It also leaves out something else the investigator noted, that DM said he believes Peterson is innocent and hopes he's released. Of course.
Okay, hang on. All right. The chat interaction. Before we continue on, how many, and you have to communicate, people, that's the whole point of the lives is the live discussion. So you got to give me something. So how many people watch documentaries or true crime documentaries on a regular basis? Some kind of heart, like, yes, no. Give me something in the chat so that we know. Either we're really delayed or nobody wants to talk to me. Yeah. So, okay. So, what is, and I have no source for this, no specific research study. I can provide it if you give me time. But what do we typically take away from these documentaries when people are talking about what they call them is the jailhouse snitch?
Mm-hmm.
What was usually the key thing that people always say? Well, they're pretty much willing to say anything if it means they could potentially get a lesser sentence or time off their sentence.
Or money on their books.
I'm not saying that's what happened, but we take certain claims with a grain of salt.
Yeah.
Because
and courts do that as well.
Yep. So, it just is one of those things. When I see some of this, I'm not trying to discredit any of this.
No.
I'm just saying that credibility is really big in court. Mm-hmm. And proving credibility is one of those things that we look at. So keep that just as a thought. I'm not swaying either way. Okay. Right. I'm just saying that when we talk about that kind of thing, I mean, and it's a sourced claim from the informal response. So we're going to say it that way, but we can't categorize the credibility ourselves. I don't know this person. I don't actually personally know anybody in these cases, so I can't say they're credible or not. I'm just saying that.
And Lacey's dug into this a lot, and the only information that could be found is this person's characterization as being DM.
Yeah. And
that's it. So
I digress. Whatever. Here we go. All right. So, and I will also say we're reporting what the defense's own investigator documented and what the final signed declaration omitted. And I will also say, because I put it in here as one of my things to discuss when we're talking about, I wrote it somewhere. I know I did. It's probably on my desk. So when we talk about one of the things that we talk a lot about cases, right? And everyone knows we have prosecution and we have defense. So prosecution is the state. You will hear us a lot of times say the burden lies with the state. So prosecution has to prove beyond a reasonable doubt to get a conviction. Okay. So when we say that, basically that means defense has to do absolutely nothing. They could come in and just sit there. They don't have to do anything. They usually try to do something, but they don't have to do anything. They are there just to, what I have learned thus far, it was a total relearning for me because I thought they were there to just declare innocence. That's not really their sole purpose. They are there to defend the rights of the defendant.
Yes.
They have other jobs as well, but I'm just saying it. So we have we have prosecution and we have defense. Now, if we take that into consent, like when we're looking with these things, okay, obviously, I'm watching this documentary and they kept saying, well, the prosecution's trying to, their story, the prosecution story, the prosecution. So in court, you will see a lot of times as we go through this, you will see the judge has to determine, and we talked about this, I can't remember which episode, but we talked about this. Some things are presented to the judge. The judge then makes a determination. It's either admissible or not admissible. And they don't want to prejudice either side.
Right.
So a lot of times what I kept coming back to with this documentary was they wanted to claim that the trial was unfair because they weren't allowed, the prosecution was objecting and the judge was saying, okay, we're not going to allow this.
Yeah.
So I just want to put that out there that it
happens all the time.
Yeah. And it's every case. It's every case that they're trying to, no one wants,
right.
They only want certain things to go in front of the jury.
Thank you, Matt, for the goat and the rose. I appreciate it.
So keep that in mind, because if you watch the documentary, they will continue to say stuff like that. They're like, well, the prosecution didn't allow this, or the prosecution did this. And I'm like, well, yeah, that's
their job.
That's standard. That's how that works.
Yeah.
But anyways, so back to this. I'm going to try to I told you this was going to be long. I gave you a warning. But anyway, the other headline piece of new evidence is what's called the, I'm going to say the Aponte tip.
Yeah.
Named for a corrections officer, Lieutenant Xavier
Aponte.
Who called a police tip line in 2003. Traced all the way through, per both the order and the informal response, Aponte relayed something an inmate named Sean Tinbrink said his brother, Adam, told him that a man involved in a nearby burglary said Lacey saw him breaking in. Now, that is several layers of secondhand information.
My brother's mother's sister.
Yeah, I mean, so both documents describe an exhaustive record search for tape recordings, visitor logs, phone records. That turned up nothing to corroborate it. And here's the detail that undercuts the claim most directly. Lieutenant Aponte's own sworn statement says that when police actually interviewed Tinbrink directly back in 2003, Tinbrink denied any knowledge of Lacey's disappearance.
Yeah. This is textbook example of why investigators chase things back to the original source instead of stopping at someone said.
Sounds good to me.
Yeah. Every layer you add between the event and the courtroom is a layer where the story can shift. I mean, it's like the telephone game. And here, the one person actually asked directly said he didn't know anything.
Now, to be fair, the documentary and the Innocence Project, the court didn't just side with the prosecution on everything. And this part matters, okay? So, here, I don't know. No one has said they've watched it. But
I know.
This part
on the claim that police destroyed videotaped interviews with two of the Medina burglars, the judge actually rejected the prosecution's argument. She found no procedural bar, and she found the prosecution did have a duty to disclose that the tapes had been destroyed rather than let the defense assume they still existed. That claim still ultimately failed, but on a different, narrower ground, the judge found everything on those tapes was independently available to the defense through other means already used, including an officer's written report and their own investigators' interviews with the same two men.
Right.
So this wasn't the court rubber stamping the prosecution. It's a real technical legal finding that just didn't go Peterson's way in the end.
Does everyone know what we mean when we say rubber stamping something?
I mean, just filed.
Yeah, correct.
Ordered.
Just like, oh, the prosecution, this is what so sometimes people will say that judges have a bias towards the prosecution.
Yeah,
so
they don't.
Anything that the prosecution files, like, if they submit a motion, granted. And then they will claim that, well, me as the defense, you're denying all of my motions. Yeah. Well, that's what people get that sometimes. They think that, okay, we're just going to rubber stamp it. Prosecution submitted it. Judge is automatically going to.
No, there has to be legal merit behind it.
And this is one of those cases where it was denied. Yeah. So this was, it wasn't just everything was in favor of prosecution.
Right.
That's what that kind of states. So why do I get the funny names? I don't feel like I know any of these names.
Croton?
That's what it is?
Croton.
I was thinking like proton.
Now, see, it's cotton with an R. That's it. Croton.
Well, I think there's two T's in cotton.
Yeah.
I'm just saying. On a Pond Croton watch, Peterson's team says the prosecution suppressed. The order documents that two separate people connected to Peterson's own defense have on the record described trying to acquire that exact watch. Oh, it's a watch back in 2003, 2004. Mm-hmm. His trial, because this is the one he supposedly got. Right. Okay, sorry.
Now we got some context.
I was like, wait a minute. because I don't pay attention to like the brand. Shut up. It is.
Let's just say it's not a Rolex.
Okay, so if you would have said Rolex, I would have been able to follow that. I would have been like, it's a watch. Like,
I wear a Garmin.
Yeah, I was gonna say, just say a watch. Anyway, whatever. So, Mark Garagos told the trial judge in a private 2004 conversation that he'd bought the pawn slip and tried to go buy the watch. A separate former member of the defense team said the same thing in a documentary interview. The judge wrote that the petition's failure to disclose this while claiming the defense had no knowledge of the watch until after the arrest treads unsettlingly close to the bounds of permissible advocacy under the rule governing an attorney's honesty to the court. And I will say, one of the other claims, which is the one I cannot talk about because I'm going to verify it, but in the documentary, they made a claim loosely I don't think can be verified.
Yeah.
And so this is kind of what I mean by this was extremely hard to do because it was going back through tons of paper, like documents. Like, I don't know if you caught Nick's. What was that? What day was that? The fishing live.
Was it Tuesday we went fishing?
Yeah, so Tuesday I was 1,566 Peterson documents in on Tuesday.
Yeah.
So when I say that it has taken, and my brain is kind of, there's a lot going on up there, or nothing going on up there. I'm not sure which. But
what Lacey just talked about with the Croton Watch, and what the trial attorney presented is just one of two formal admonishments in this order. The other is about testimony from Detective Bracconi regarding reported sightings of Lacey. The judge found Peterson's petition quoted that testimony selectively.
Yeah.
Cutting out the context of what time period the detective was actually being asked about in a way that made his testimony look false when read in full. It wasn't.
Yeah.
Twice in one order, a sitting judge said a habeas petition came close to crossing an ethical line. That's a serious finding, and it's worth being precise that it happened twice on two different claims, not once, and not about the piece of new evidence getting the most attention in the documentary. Yeah, so what you can see here, it's obvious that it's a convicted murderer grasping at straws. I mean, they're going to fight everything. They're going to do everything they can to fight for their life. It is a person regardless. And that is, honestly, that is just what's going to happen.
So with that, so this rule is about the lawyer's basic duty not to mislead a judge.
Yeah.
So that means what they leave out. So when you
happens all the time.
When you go through a court process, okay, there is a huge piece of that process that is discovery.
Yes.
And you have to present, both sides have to have access to the same information.
If you know information exists and you leave it out intentionally in a motion or anything that's going to be going to a judge or into the justice system, and you intentionally leave that information out.
Yes.
And you know that information, it can fly. It can fly
it's a little
sometimes.
Unethical. I mean, yeah.
It can fly sometimes if you truly believe that it has nothing to do with the merits of the case. However,
it's supposed to be decided by the judge.
If it is found out that that information has complete merit to the case
and was left out intentionally, right, there's issues.
Yes.
And it's treated as a foundational like ethics rule for attorneys. And it's because it's supposed to be, we have due process. I don't know if we've specifically talked about due process specifically as far as what that means exactly.
Yeah.
But you are entitled
Due process.
to due process.
Yeah.
So
It's your constitutional right.
it's tricky, and you're supposed to walk certain lines, and they sometimes can get really close to the line to see how far they can push things.
But we'll say this, that the court's own finding, there was not a formal violation or sanction.
Right.
It came close to violating those statutes to be sanctioned, and we want to state that there were no sanctions in this. However, they were admonished for those instances.
So, Matt, a lot of times you have that's a lot. This is really hard to cover, but when it comes to judges denying evidence, there's some of the most standard things are prejudice. So a judge could say, okay, I'm not going to allow this.
It auto-posted. Sorry. I'm so sorry.
To what?
It's all right there.
With evidence. Okay. So, and there's things. Okay. So there is also like fruit of the poisonous tree.
Yeah.
Mm-hmm.
We're not talking
about that yet. But that is doctrine that goes into it.
That's different.
It is different, but how evidence is obtained, the chain of custody. So it gets some things get thrown out with that method because it was, we couldn't verify that. Basically, in chain of custody evidence type thing, it could be, well, this guy put it in his pocket and then he went home and then the next day he turned it in. Well, we don't know what happened to that piece of evidence during that piece of time. Officially, there's no way to know. It's just that person's testimony. A lot of times that evidence is thrown out because it's like, well, we can't, say that was.
Yeah, and
that's not fair to let that in. We can't prove that was legit, if that makes sense. That's an example.
The sides, the prosecution and defense in a criminal case, they're the ones that have to present a motion to suppress evidence.
Correct.
A judge on their own can't just say, boom, nope, that's not getting in there. There has to be a motion to suppress.
Okay, so here's another one of those examples. So there's also, in my brain, I can't come up with it. But so there is a thing where beyond the scope. So if we're talking about we're in trial, for example, a lot of times evidence can't come in unless, so whichever side it is.
Be right back. Hang on.
It could go either way, but whichever side it is has to open the door. And it's usually the witness that is testifying that opens the door. So say, for instance, I am I'm in the box.
Yep.
Okay. And I'm testifying and Nick is doing his examination. And he says to me,
I ask a question that brings up new evidence that no one knows about.
You can't do that
right.
So he says, where were you Friday night? He's really trying to get in that I was at Josh's house, but they can't get that in unless I bring it up. So when he says, where were you Friday night? And I'm talking and I say, I went to dinner and I went blah, 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 blah. And then I let it slip. Oh, I was with Josh.
Who's Josh?
Now it's been brought into the case. It can be discussed. It's just a name. I'm just saying, I'm throwing names out. Whatever.
Who's Josh?
I guess you'll have to take me to court to find out. But anyways, that's kind of that as well. So there's lots of ways.
Yeah, Matt, that could be a whole episode.
Yeah, so hopefully that clears that up a little bit.
Clear as mud.
I know, that's our thing. Always clear as mud. So back to Peterson. On DNA testing. So per the informal response, this was Peterson's fourth request for post-conviction testing. So testing on the same mattress cloth back in 2019 already came back negative for blood. The item approved for new testing was a single piece of duct tape recovered from Lacey's pants. Testing conducted by a lab called Pure Gold Forensics completed by August of 2024 with the results filed under seal. As of the most recent reporting we could find, those results have never been publicly disclosed. Mm-hmm. So, that is all I can say about that. I I cannot speculate.
Yeah, the state plainly said that they're sealed and undisclosed.
So
That's it.
That's about as complete of an answer on the DNA that
But
we can give you.
there has been recent testing on items that came from Lacey's clothes, a piece of duct tape that has been gone through a private forensic company.
And that's not uncommon.
Nope. Defenses do that all the time.
Like with the Wells case, you can a lot of times when
I
there's
just want to say this guy's spending a lot of money, and I don't know where he's getting it. It has
the Innocence Project did most of this.
It's crazy.
They picked it up, so they foot the bill. So we talked briefly about that with the Wells case. A lot of times you can request an independent, like autopsy and things like that. You can do when there's questions in regard to like the law enforcement that's handling the case or the state. You know, sometimes families don't believe that there was no corruption or things like that. So they will seek that additional outside private, you know, testing. There's forensics, there's autopsies, there's all kinds of things. So they can request that. And a lot of times they do, especially if it's this kind of a case. And sometimes the defense, you know, foots the bill as well. It kind of just depends. But
there is a second.
I was getting ready to say, are you going to talk about that?
There is a second separate habeas track in this case, and it's the juror misconduct claim involving juror number 7. Rochelle Nice.
Nice. That's hard to see it, but
they decided by a different judge in 2022 and still pending before the California Supreme Court. So don't mix that up with tonight's petition because there's 2 different claims. What we've been talking about, plus there's the other habeas track, which is the juror misconduct.
And maybe also, if people would be interested, jury selection is a whole thing. Voir dire is a whole. It's a whole thing, and I don't know that people understand voir dire and how like jury duty comes about. But in the voir dire process,
if you answer if you answer questions in the voir dire process and then later on you have follow-up interviews, because typically you do have juror interviews after a case. The defense wants, like if a defense loses a case, in this instance, the defense lost. They lost. They didn't get their outcome that they wanted.
You're going a different path than I was with voir dire, but okay, go ahead.
The defense has the ability. The defense has the ability to interview the jury after the case is decided, after sentencing, after all of that. Now, it has to be, the jurors have to agree to do that. However, when that is done, they're going to be asking questions. And if you answer those questions differently than they were asked during voir dire, they can bring that forward.
I was going to touch on with voir dire, the whole process is people have a very loose understanding of that process because defense and prosecution are both involved in that.
Yes.
And when it comes to that, they both have to be in agreement on the jury and the jurors that are selected. Yes. So it is a very in-depth process where it's not just, okay, well, I've got jury duty, so I'm going to sit on this jury. That's not, they both have to agree. And a lot of times how they pick the jury and select the jury is very specific. And they will look at, well,
it's a science.
Yeah, the defense and the prosecution, they will go in great depth, especially on a case like this, to determine the background of the individuals. Yeah. Because they'll say, well, no, that person, this or that, I want them thrown out.
Yeah, they have a brother who killed their wife. And,
so it could be something. And they both have to agree before they are seated. Yep. So that's a whole different thing. If that's something that we would like to discuss on an episode more in depth, let us know.
We can put a pin in that one.
Yeah, we can put a pin in that. That's a whole process.
The order also lays out, in the judge's own words, evidence the jury already had against Peterson. A hair matching Lacey's mother's DNA clamped in the jaws of pliers in Peterson's boat. Concrete debris in the boat cover, now not the boat, but the boat cover, matching both his homemade anchor and his own workbench. His admitted lies to police about his affair with Amber Frey. and a recording of his own voice weeks before Lacey disappeared, telling Frey he'd lost his wife and that it would be his first holiday without her, made per the order the same day he bought the boat. Kind of damning.
He was not a very likable guy.
Yeah.
Like the way that, I mean, just some of his things, he just was not necessarily Mr. Nice.
One more direct finding from the order itself on page 115.
All right, I did put it in.
The judge wrote plainly that Peterson's claim that Lacey knew about the boat was presented at trial and not new evidence.
I'm just going to say it
That's
because
her own language, not our summary of it.
It's in the documentary.
Well,
I'm going to say it. Give me a second
okay.
because I'm going to pull this up. I got to pull this up. Where is it at? Oh, it's on my desktop. Oh.
So this exact quote is confirmed from the order per page 115 of the order, but we don't.
Okay, so here's the thing.
We don't have the surrounding paragraph in front of us.
What I can tell you is in part 1 of the documentary that just aired, Pixley, who's basically your main narrator of the whole thing.
Right.
Okay. He claims that the defense. Okay. Let me backtrack. So this chunk of the documentary, they are discussing Post-it notes that are found, and there's the question of whose handwriting is on the Post-it notes.
Yeah.
So. They each have their independent verification. Like, one in the documentary, they use a lady who started out with Secret Service, and she is the
subject matter
handprint.
expert.
Yes.
Yes.
And she can look at this, and it's like 2.5 years of training that it takes.
It's a lot. Yeah.
But basically, she's looking at this, and they have a sample for Lacey, and they have a sample for Scott, and they ask her to compare the samples to the Post-its. Same thing. Again, I cannot find that page number exactly in the original court documents, and that's what I want to verify. But they're claiming that defense the direct quote, defense wasn't aware of Post-it notes until 2024. So Pixley said that the defense didn't know that those Post-it notes existed until 2024. But I am 99% positive that they did, because I believe they were brought up in the trial, because that's why they were claiming Lacey knew about the boat.
Right.
Like, I'm pretty sure I got to double check it, because prosecution claims Lacey had no knowledge of the boat, and that, defense's claim was that she knew.
Mm-hmm.
Prosecution's like, no, she didn't. He bought the boat to dispose of her. So that was a huge part of the trial, was whether she knew about the boat or didn't know about the boat. Did he buy the boat just to dispose of her body? So that's why this documentary is going in great detail to discuss the boat in question. And
does it even matter?
Well, what I'm saying is, when they claim this, I was like, I think that they knew about it before 2024. That's what I'm saying. So that's why I didn't want to talk about it, but that's what we're referencing when we talk about page 115. And I wanted to talk about that because it's in the documentary, and I literally paused, rewound, because I was like, wait, what did I just hear? Did he say 2024? It literally caught me by surprise. So that's all I'm going to say is that
I'm not surprised that a defense attorney would say that, because our own personal
we don't talk about it.
Our own personal experience.
Okay,
that's
I
all
understand.
I was saying.
You like to
You think I'm going to go into things.
You tread very close to the line, sir.
Well, that's what I was born to do.
No. So anyways, this exact quote is confirmed from the order per page 115, the one that Nick said, where it was presented at trial and not new evidence. Okay, so that was whether Lacey knew about the boat. I don't have that paragraph again, And then, in the documentary, it covers the specific notes and Pixley's references. I want to.
No, you can't. You've already.
It's out there.
Yep.
People already know. I guess it is what it is. People throw whatever they want out there anyway and say whatever they want. I'm just saying I want to do a little more research before I can put my feet in the sand.
Honestly, with this case, it makes no difference whether she knew about it or not prior to. When you really think about it. It makes no difference.
Well, also in the documentary, they spent a lot of time doing a lot of, they claim
they are trying to exonerate a murderer.
But I'm just saying, they say, that the expert that talked about, they just said the wind, he didn't account for any tides in the water. And I just feel like some of those are very loose claims. I'm just
free a guilty man.
But.
And if they are successful.
That's a win for them, literally.
Exactly.
Literally.
Straws.
I'm just saying.
Yes, Jess. 100%.
Take it with a grain of salt. There's a lot of court documents and it's a lot of flipping back and forth. So here's where that leaves us. Based on documents that we have read, and now when I say we have read, it means I have read them, but when I watch the documentary, I have to keep going back and forth and back and forth. So it's a process, my friends. But anyway, cover to cover on the parts that matter, the claims trace back to a filing that existed months before it was framed as new. So the court's own record shows the two most specific new claims, the Aponte tip and the Croton watch. They don't hold up against the documents already in the file. One of them serious enough to draw a formal ethics finding, alongside a second separate one on unrelated testimony. And the one claim where the judge actually pushed back on the prosecution still failed on a different technical ground. None of that means the Innocent Project is acting in bad faith as an organization, but new evidence and a new attempt at or to litigate old evidence undercut by the file's own contents are different claims. And on the record we read, the court found it was the second one.
Lacey's mother, Sharon Rocha, is referenced directly in the DA's press release. 2 years ago, per that release, she addressed the court through a letter and asked simply, quote, "When will this end? California's Constitution, through what's called Marsy's Law, guarantees crime victims' families a right to, quote, a prompt and final conclusion of the case," end quote. There was a prompt and final conclusion of the case. He was found guilty of murder. I'm sorry. I don't like people.
So here's... Okay.
I understand this is the mother of her deceased daughter. I get that. And they're wanting conclusions. You got your conclusion.
Yeah,
the court gave you the conclusion.
But she didn't, because every other year you turn around and you have to be drugged through it all over again.
Well, it's called something happened.
I'm just saying, I understand her whole thing, because it's like, okay, yes, we had our conclusion, case closed. We thought.
That's it.
But then he gets the chance to appeal.
He'll have the chance for the rest of his life until it goes to the Supreme Court, and the Supreme Court says, "You're a murderer. Stop."
I'm just saying. I was talking to my dad today on the telephone, and because he asked how the podcast is going, and I told him, I said, what we're going to talk about, and he was like, "Oh," and I was like, "Yeah, it's a big one." And he was like, "So what's," and I kind of gave him a rundown of it, and I gave my spiel to him, my take on it. Obviously, he's my family. I'm going to say, my unbiased, straightforward response. And I said, at this point, it's appeal after appeal after appeal. And he said, "I don't understand why they have to keep allowing the appeals." And I said, because that's the process.
That's the law.
That's the law.
Justice
you have
system.
to allow for the appeals.
Right.
And that's why a lot of times we can't, we put people on death row because we can't, again, there's so many variables and things, but
that's
we can't
because
just
the justice system doesn't always get it right the first time.
Exactly. So we have to allow for appeals.
Mm-hmm.
And so, playing devil's advocate on this, we have to allow him to exhaust all avenues
that are allowed.
However, on the victim side of things, okay, so I guess that would be angel's advocate. I don't know. I don't really, you only just hear devil's advocate, but
victim's advocate.
The victim's advocate side. I look at that and I think, how horrible to be constantly this part. You can never move on. Like, it would just be like a constant state of reliving. And like, you turn on the TV and it's on the TV again. And it's like, you couldn't escape this. And I get where people are like, well, they just tone it out. Well, you can never heal from it. So I get where it comes to the point where it's just like, when is enough enough?
So just kill them.
But we can't do that.
Well, I mean, if you want to be a victim advocate.
I'm just saying, if you look at things from both sides, do you see what I'm saying? Like, that's why it's really hard for me, because I'm like, wait, I understand the family, but I also understand, because I think in my head, if I'm on trial for something like that, I want them to get it right. And I want to know that it's right. I mean, if I'm guilty, I'm guilty. But if I'm not, I want to have the opportunity to present my case.
Yes. And everyone has their opinion. And that's all it's gonna come down to.
Who tells the better story?
That's it.
The most persuasive.
Yep.
And again, none of this is legal advice. It is our analysis, our opinion.
Yes.
Boom. So that's a lot of ground on Peterson tonight. Before we move on to the next section, does anybody have any questions or anything in regards to that? And again, I will say, like I said, I'm 3/4 of the way through the first episode. So I have a feeling Monday night's episode could potentially be covering part 2. I don't know. What are we thinking? I don't know if there's a delay. I also see
we lost like half of our viewers after I posted up the Nancy Guthrie page.
No, it wasn't.
Yeah.
I think we got some streaming issues. I don't know if there's a delay.
Good.
Oh,
is that Aunt Tracy?
Its own series. I know, but you see, like, that's the thing.
Not.
I don't know how many people have actually listened to the Casewalker Chronicles season 1, the podcast.
I'm gonna throw up the crickets again.
Chirp, chirp. Like a Ball State Cardinal. What happened?
Nothing.
Oh, well, we froze there for a second. Most of it. Okay, so
Mom did.
So then some of you know that I did do a series. I call it a series. It was a part 1, part 2, part 3 of a Indiana case. So in theory, I could potentially talk about any case over an extended period of episodes.
Yes.
So I could do that. I could do, if we would like to extend the Peterson case to Monday night, we could cover Peterson a little bit more on Monday, but it would be part 2 of the documentary.
I'm sorry, this is my opinion. The dude is guilty. My opinion. I can give that on the particulars.
I think, I don't know.
Sorry.
I mean, I think the handwriting thing kind of threw me a little bit. I got to rewatch the episode. I mean, did the Innocence Project, sway my opinion? Maybe. I don't know. I will say I do really like the Innocence Project as a whole, because I feel like the majority of what they do in a lot of ways is good. The burglar.
Yeah, the burglar.
Were you burgled?
I was burgled.
I'm just saying. I don't know.
Get out of here.
No, I do. I do think he's guilty, but I'm just saying. I mean, at this point, he's had so many appeals. Like, okay, honestly, I'm just going to be honest about this and the way that I look at the law. At this point, if every single time, unless there was literally so much prejudice, how can you have so many appeals and time after time and time after time do you get the same answer? Like, that's where I kind of start questioning. I'm like, okay. and again, that kind of goes back to what we talked on in another episode where we're talking about evidence. So
Yes, Mom, we know.
so the you know, when we look back at some of that, it's like when we say new evidence, in theory, unless we've buried it.
We're beating a dead horse.
I'm just saying. I'm just trying to give him the benefit of the doubt.
Yeah,
like you can't really have new evidence.
We are putting what is out there now because it's technically not new evidence because we talked about that earlier. It's not new. It's
or if we came at it as a way that, okay, all of this was suppressed from the trial, it should have been admitted, it was not, then technically I would give it a loose interpretation of new evidence.
You bring that to the Court of Appeals, and the Court of Appeals makes a decision on that, which they already did, and they said no.
I'm trying to get it.
I know.
Because people think of it like that's what frustrates me is we throw this out there as a documentary and people are like, what? New evidence?
Yeah, no.
Like that's
No.
But that's what people see because they see it as a headline.
It was brought forward in other habeas petitions, and he was told no.
Right.
His attorneys and his defense was told no because, look, we didn't get it wrong the first time.
But they do sometimes get it wrong. So
yes,
I get
happen.
that we have
But we
that
will
system.
continue to bring it through the court systems, and he's trying to make a Supreme Court case. That's all it is, and it's gonna get to and that's what's scary.
At least has he wrote
Here's
a book?
the thing, I'm sure. This is what's scary about being a convicted murderer and going through the appeals process.
I was going to say you have unlimited amount of time on your hands. Think about it. If I had unlimited amount of time to do case research,
you do.
But if I had more unlimited time,
here's the thing. Think about it this way. You are guilty, okay? Let's just say in your head, you know you committed a crime and you've been found guilty. Well, yes, you do have the process that you can take through appeals. But just know that the last step is the Supreme Court.
Ooh.
And once you make that move through your different courts of appeals, because there is a succession to it. Once you make it to the Supreme Court, there is no one above that to make another decision. So the decision that they make is final.
So here's another little tidbit that I want to put out there. Okay, so when we talk about cases, right? So we're supposed to have a fair and speedy trial.
Yes.
Well, anyway. So on the fair process, it's supposed to be unbiased, all the things. Yep. So in theory, originally, we look at it as, say, this information, we could sequester the jury and things like that. But in theory, his very first trial was his only fair trial, his first trial. Because who today could you get to put on a trial? Like, who could be a jury and say, I've never heard of the Scott Peterson trial. What? Who's this guy?
18-year-olds?
I don't even think that. I'm just saying.
I bet our daughter does not know who Scott Peterson is.
I'm pretty sure she probably does.
I bet she doesn't.
Call her up. Put her on blast. But anyways, I'm just saying, like, if you think about the way that system works,
yeah.
Because each time in theory, if it's retried, you could have, a different set of jurors, but it's like you kind of have lost your.
Yeah, but if you're doing it that way, you definitely, as a defense, you definitely have the information to really sway and put that reasonable doubt out there.
And that's the thing. I listen, and they'll probably never ask me to be on a jury because I think beyond a reasonable doubt is an unimaginable.
Hey, you want to know why? You want to know why I've never been?
Just joining us at this point, you've missed a good chunk of the episode, but
that's okay. You can go back and rewatch it at some point.
Yeah, you can catch the
YouTube.
replay on YouTube whenever it gets to YouTube.
Yes.
And as always, like, follow, share, subscribe.
Tell your friends.
We're here every Monday, Wednesday, Friday at 9 p.m. Eastern time. And we do put snippets of our stuff out. Mm-hmm. So
follow us on TikTok.
Please
Instagram.
share if you think that someone could enjoy what we have to say or benefit from the knowledge pieces that we put out, give them a share, tag them, all the things.
How many of the lawyers are from the OG crew back in 04?
Oh, most of the time you can't. Most of the time they're
with appeals you have
they're
a lot of times
appellate lawyers.
Yeah, you have to get different attorneys.
Now they can like interview, so to speak.
Yeah.
The prior defense attorneys, but most of the time, and there's a lot of different attorneys and they specialize in different things.
Right. There's a difference between trial attorneys and appellate attorneys.
Because it's not different law, but it's different. It's different.
Yeah. The way you present it in court is different from a trial versus an appeal.
So that's a good question. Again, we could also talk about that one time. But, so with that, back on our very first episode.
Matt's like, this is stupid. Why do they have all this?
There's a lot of rules. There's a lot that goes into law.
It's not necessarily rules. It's playing the game is what it is. It's playing the game. Think of it as a game of basketball. That's it. You're going to put your best players in against the team that you're playing.
Okay, that's why when you say it that way as a game, yes, because
that's why you scout the team you're getting ready to play, and you're going to run plays that are going to be beneficial to you versus the team you're playing. And the team a defense is playing at trial is different than the team they're playing to a judge during an appeal.
So appeal is different because it's not a retrying of the case.
It could lead to that.
It could, but it's usually, and again, we'll have to maybe cover that.
It's a judge's decision that makes it whether or not it goes back to a trial.
It's based on the facts and the original trial, how it happened. It's not, you don't like put new evidence. It's more so like,
it's not that the law is different, Matt.
I'm answering it.
I'm interacting.
I'm answering the question and you're cutting me off, sir.
Okay, ma'am. I'll let you finish.
Thank you.
Sorry.
Take a number. Have a seat.
104. Gee.
So anyways, what an appeal usually is it's an attack on the original trial. Meaning, like, say, for instance, if the original trial, the judge ruled the Post-it notes non-admissible, then the appellate attorney would say, hey, he was denied his now you can chime in, his he could not defend himself and so to speak, because this wasn't allowed in.
Yeah.
So all possibilities weren't allowed, then they can use that. That's kind of the process of an appeal. An appeal is not like a new trial. It's kind of just an overlook of what went wrong or what they are claiming went wrong with the original trial. Mm-hmm. They have to have a claim for why. Now you can chime in.
Nope.
He's done talking. He's like, I'm not talking. Well, you get to talk about...
No, not you.
Talk about it.
I hate this case personally.
Okay, so here we go. He's pouting. I know.
I'm not pouting. I just don't.
He doesn't want to talk about this case, but it won't go away. I'm sorry. That's terrible. But anyways, we're not going to assume you caught the first episode because
we already talked about this a little bit.
So Nancy Guthrie, 84, is the mother of Today's Show co-anchor Savannah Guthrie. Per reporting from Wikipedia's source timeline and multiple outlets at the time, she was last seen in her home in the Catalina foothills area of the Tucson, Arizona on the night of January 31st, 2026, and reported missing February 1st. Investigators found blood on her front porch and concluded she was taken against her will. A doorbell camera reportedly captured a masked individual tampering with the camera that night. No suspect has ever been named. Tag, you're it.
What's new since we last covered this? News Nation reported that FBI Director Kash Patel said publicly that the sheriff's office delayed requesting FBI assistance, which he said could have impacted the investigation. The same News Nation report says Sheriff Chris Nanos pushed back, stating his office provided, quote, immediate local leadership and oversight, end quote, from the night of the incident. And per Men's Journal and Newsweek's separate reporting, the FBI and the Pima County Sheriff's Office put out statements within about an hour of each other that didn't line up. The FBI's statement said local authorities remain the lead. The Sheriff's Office statement said questions about the ransom notes should go to the FBI. So when multiple when multiple agencies share jurisdiction, figuring out who's actually lead is usually a quiet internal conversation. And I've dealt with this personally when I was back in a tangent. This happens. From my experience as an OSI agent in the Air Force, we had multiple times where we were the investigative lead, and Grand Forks PD in North Dakota was a supplementary agency we could use. Now, there were other instances where they were lead and we were the backup. Now, that really comes down to our special agent in charge at the time having a conversation with the police chief or the sheriff. And it's really behind closed doors. And they say, okay, we're going to be the lead on this. Or, no, we're going to be the lead on this. So compare this to our jurisdiction examiner or explainer on Wednesday. The Horn Island had 4 agencies with overlapping authority and no public conflict, at least none reported. 2 agencies publicly not agreeing on who's in charge, as multiple outlets are now reporting it, is a different picture. So with that being said, this is kind of a Charlie Foxtrot, which is why I really didn't want to talk about this case, because it's like, oh, let's give information to the FBI. And then, oh, no, let's give information to the
But
Sheriff's
I think it's
Department.
because, like, a lot of people, so the FBI is such a large, when we talk about, like, investigations, I'm not saying anything
their
bad.
resources span
Yes,
way
they're
more
huge.
than what a
And
sheriff's office
if
can.
you look at your smaller local jurisdictions, when it comes to, like, your sheriff's offices and even your city police, most of the time they don't have the funding or the resources that your federal agencies have. So a lot of times...
And another thing that ticks me off about this, and I don't want to cut you off, but it is the root of why...
All evil?
No, it is the root of why I cannot stand the media. Because a lot of this reporting is coming from the media. Because there hasn't been a resolution.
There hasn't been a charge.
There hasn't been a charge. There hasn't been a resolution. The media wants to stir that shit right up and say, well, the FBI is supposed to be lead. And then they're saying that the sheriff's office is supposed to be lead.
And here's
so let's cause conflict and let's sell the news.
If anyone saw our clips that we pushed out, there was one where we talked about jurisdiction, and then there was also one where we talked about the glorification of a case. And what you see, this case is one of those ones where it was so public.
Let me just tell you that the news did not get the story, did not get the result that they wanted.
Well, they wanted it was a simple, I think, okay.
They did not get the story that they wanted this to be they did not get the outcome. They wanted an outcome, and there isn't one.
Well, they were hoping, I think, and this is my opinion, again, I think with this case, they were like, okay, everybody loves Savannah. Everybody knows Savannah.
Well,
so
yeah,
they're gonna feel very sympathetic, and they wanted to get that information out, and no one wanted to be the one that was like, well, I'm not gonna push that information because they didn't want, the Today Show or whatever to be upset and that's just my personal take on it. It's how the political game is played among media.
Yep.
But it's like, what happened, in my opinion, with this was because it was such a saturated news story, it just continued to feed what we also discussed with how is anyone supposed to conduct an investigation when it's so saturated. And I say that like, so we bring that back to the ransom notes. Okay, so Reuters reported specifically that on June 30th, an FBI official told them none of the ransom notes were believed to be genuine. Then, per a statement the FBI's Phoenix office posted publicly, which Newsweek and other outlets picked up about 2 days later, the FBI said some notes were, quote, extortion attempts without legitimacy, end quote, while others may, quote, may potentially be legitimate and are still being investigated as such, end quote. And IBT Times reported that a retired FBI agent, Steve Moore, said in an interview that he believes there's, quote, significant disagreement within the FBI investigation on what they're dealing with, end quote.
Yeah, we don't speculate on Nancy Guthrie's condition or whether she's alive.
No, because I mean, I'm not going to talk about it, but all I'm saying is it's like when we have a case and it gets such national coverage, there are some cases, yes, where the more eyes on it, like if someone's missing, that is great, because if we think about the way things, just going back to algorithms, okay, we all have our own
belief.
No, we all have our own For You page. They're all tailored to us specifically.
That's what we believe.
We all aren't seeing the same thing. We just proved that because all my news feed is cases.
That's not proof. That's
okay. It's a study. We are conducting a study. I didn't say it was a blind study. I just said it was a study. But what I mean is that in a lot of times, and it's also more geographically situated. Mm-hmm. And so like when we have Indiana missing persons, most of the time it's just our locally news that's picking it up. And when we think about that, the danger of that is that this person, say, could be in California, but if California news doesn't know that this person's missing from Indiana, they don't know that they should be looking for. So that's why the national news picks up some stories, but it also is like a double-edged sword.
I choose to believe what Jess said.
What it... Hey, I'm not saying that couldn't be the case. There are some cases where Nick and I strongly disagree on. I'm not going to throw those out yet, but there are some missing people that I say are genuinely missing, and Nick says they wanted to disappear.
Yep.
So what it is, we may never know, but...
Hey, guess what? We're at 10K likes.
Yay!
And we're getting there. We're almost done for tonight.
Yeah, we are. I'm just saying... One more thing worth knowing if you're following the case. On July 13th and 14th, the Pima County Sheriff's Department posted directly to its own X and Instagram accounts, warning the public about a scam. Social media posts using a QR code asking people to send money tied to the Guthrie investigation. Their statement, quoted consistently across Fox 10 Phoenix, The Hill, and several other outlets, reads in part, quote, PCSD will never ask for money related to this case or any investigation, end quote. Sheriff Nanos told People. The warning followed a truck spotted driving around Tucson displaying an AI-generated image soliciting money for the investigation. If you see anything like this, it's not real. Report it. Don't send money.
Last piece per IB Times, UK's reporting. A woman named Coral Michelle Smith was wanted on an unrelated kidnapping and assault case less than 7 miles from Guthrie's home and got attention online as a possible connection. The same IB Times UK report states investigators have formally ruled her out. Worth being precise about the difference between a person of interest, someone investigators want to talk to or haven't yet excluded, and a suspect, someone investigators believe actually committed the crime. Per that reporting, Smith was never named as a suspect. and is no longer even a person of interest.
And also, for a recap on that, no change, for Derek Kalela, who pleaded guilty to sending fake ransom messages to the Guthrie family, is still set for sentencing September 10th, per the plea agreement reported at the time. That's a separate resolved piece from the actual disappearance, which remains open.
You're an idiot!
So, presumption of innocence applies to anyone eventually named as a suspect. No suspect has been named. Everything in this segment is secondary reporting, clearly attributed by the outlet. It is not verified reporting, and we have to say that because, like I've said, there has been no charge as of the time of this live.
Right. There's no primary document
So there's
available.
no court docket.
Right.
There's no
court filing.
There's no,
no
probable
press
cause
release.
affidavit, no nothing.
Yep.
Nothing has been official. So in regard to that case, it is extremely hard for me to come on and talk about the case because a lot of it is just news reporting.
Yeah, that's where things stand with both stories tonight. One's grounded in documents that we've read ourselves. Well, Lacey has read for the most part. And one is entirely on news media and other people's reporting. And also what we've said. So
I will also say on that note, because I feel like it needs to be stated, in regard to court documents, so the standard for, we talked about that at the beginning of the show, like how I kind of go through my sourcing and things like that. In regard to court documents, no, not everything submitted to the court is like a fact, but the way that we kind of process things and how some things go forth. So when we talk about like a search warrant, we talked about the ladder and, we got your probable cause, beyond reasonable doubt. Excuse me. We talked about all of that.
in a previous episode.
Yes. With court documents, once things have been submitted in trial, that is part of the case. And when it comes to motions, unless the judge has ruled on a motion, it is just a motion.
Yes.
But I find it more legitimate as a source than a random
news report,
Facebook post or thing like that. Like even Wikipedia, because anyone can submit to Wikipedia. So now we have a moth. I swear to gosh. What kind of place is this? I tell you, I mean,
really?
We're not going to talk about that either.
I know.
God love. This place is a prison.
That's our breakdown. Court record versus documentary claims. We'll keep watching this one as the...
Does anybody have any questions or, topics or cases that they would like us to cover potentially for Monday? Do we think we need to cover Peterson Part 2 on Monday?
We love our chapalonis.
What else would we like to discuss for Monday? Anybody got any ideas, or are we going to see what happens on this fine weekend? That's when all the fun happens.
Mm-hmm. Hey, we're supposed to go boating tomorrow. We'll see how the weather acts.
It's been storming.
Yeah. Pop-up storms.
Oh my goodness. Maybe part 4. Okay. We'll just continue to do, I'll do a whole nother, it'll be Tuesday, Thursday nights. We'll just cover the Peterson case from start to finish.
Yeah. No.
Could you imagine? I mean, first of all, 6 appeals, like that's a lot. Like that would take forever to get through. Well, if anybody comes up with anything, you are always welcome to DM us. Again, love the shares, love the likes. Thank you for all the gifts. We hope you have enjoyed your Friday evening. And I will say we have kept this under 2 hours.
Surprisingly. We did only have really 2 topics to talk about tonight. So
well, because I thought I thought Peterson was going to be such a hefty topic, and there was a lot to cover.
Yes, it is.
And there's also, if there's any questions about things that you have in regard to anything we've covered, or if you want a longer explanation of some things, let us know. We can try to cover some things. Like I know we talked about voir dire and things like that. So Any ideas for, particular episodes moving on, just let us know. As of right now, everything leads us to believe that we're going to be back on Monday. It seems like people showed up and participated. So
Yep. We're going to continue this thing.
As long as people show up.
Yep. And we want to definitely thank those viewers who stayed with us tonight. Again, you are the first fans of something that is going to be huge. I'm telling you right now, there will be people coming to our table at CrimeCon wanting our autographs one day, and you will get to say that you were the first ones watching our podcast, the very first, and we love you for that. Thank you so much for the support.
Also, we've said it, we'll say it again. If you missed any of the previous episodes of The Particulars, they are on replay on YouTube under the Casewalker Chronicles.
Yes.
We do have our season 1 of the Casewalker Chronicles on podcast. That is a full, complete season. It is up. You can listen. You can binge it.
It's all free.
And everything on our we actually everything's on YouTube.
Yeah.
The podcast and everything's on YouTube. So. Yep. If you want, YouTube's a really quick, easy way. We do have Facebook, TikTok, Instagram,
all the socials,
YouTube. So you can like and follow us all those places. We will try to keep you up to date. But otherwise, I forgot what we close out with. I can't remember. He already said it.
Yeah, I did. We're done.
Oh, well.
It's Friday night. Go enjoy your weekend.
Yes. We look forward to seeing you all on Monday. Bring a friend, tag a friend, tell a friend. We'll see you guys on Monday night, 9 o'clock, same time, same place. Bring your questions. We'll have a discussion.
Love you all.
Thank you, guys. We'll see you Monday.